Now, forensic analyst Paul O'Sullivan is expected to continue giving testimony today at Parliament's Ad Hoc Committee investigating allegations that were made by the KwaZulu-Natal Police Commissioner, Lieutenant General Nhlanhla Mkhwanazi. Now, during his testimony yesterday, O'Sullivan's academic qualifications came under scrutiny, with Ad Hoc members questioning his background and credibility. His appearance follows an initial pushback and insistence to appear before the committee virtually due to possible security threats. Now, to further this discussion, we joined virtually now by Advocate Mbalenhle Mthembu, who's a legal analyst and a member of the Durban Bar. Advocate Mthembu, thanks so much for your time and welcome to Morning Live.
Thank you so much for having me. Good morning to you too.
Advocate Mthembu, first and foremost, so Paul O'Sullivan finally appearing in front of Parliament's Ad Hoc Committee after that to and fro about whether he'd appear virtually or in person, ultimately appearing in person. So legally, if he refuses to answer any of the questions, as he has indicated previously that he didn't want to be questioned by some members of the Ad Hoc Committee, he also stated that he views this as a kangaroo court. So where does that place him legally?
Okay, so before a witness gives their testimony before the Ad Hoc Committee, they are placed under oath or admonition. And Section 16.2 of the Powers, Privileges and Immunities of Parliament and Provincial Legislators Act states that once a person appears before the committee, they may be required to answer any questions that are lawfully put to them. So even if those questions will incriminate that witness and will open them up to criminal or civil proceedings, they are required to answer those questions. And then Section 16.3 further goes on to state that evidence or testimony may not be used against that witness directly in any place or court outside of Parliament, where the person except in situations where that person stands on a charge of perjury. So that goes on in Section 17(1)(c) that states that failure to satisfactorily answer questions that are lawfully put to you by the Ad Hoc Committee without just cause attaches charges of perjury, or rather charges of refusal to answer, and attaches penalties such as imprisonment of up to 12 months or a fine or both. So there are implications for refusing to give that testimony, and Parliament then has the right to pursue charges against that person for refusing to testify fully.
So just to push that clarity further, so does this mean that no one can rely on the person giving evidence before the committee's evidence for either civil or criminal claims arising from that testimony?
So what the testimony can do is that it can trigger investigations into those allegations. So those investigations, if they turn up corroborating evidence, and if they turn up any further information that can justify charges against that person, then that person can be pursued with criminal charges. But the testimony alone that's given in the Ad Hoc Committee cannot then directly be used to file charges against that person without any further investigations and without any further corroborating evidence or information.
And are there any further legal protections for people appearing before the Ad Hoc Committee?
In terms of legal protections, of course, the information is provided under oath. And if a person testifies truthfully and provides information fully, that obviously then means that the committee can then use that information in its report to trigger further investigations. So, you know, it's up to the prosecuting authority in terms of what protections are afforded to that person, how far they are implicated in the issues that are raised. So that is obviously ultimately up to the prosecuting authority.
So O'Sullivan yesterday had his academic qualifications under scrutiny, his experience in forensic investigations also being placed under scrutiny yesterday. Did you find him a credible witness at all?
So testing the credibility of a witness involves really evaluating the truthfulness, the reliability, and the consistency of the testimony that they give. And that is done in various methods, such as cross-examining, rather questioning that witness, testing their demeanor, testing whether there are any contradictions or inconsistencies with information that they provide to information that they've provided prior, and just testing the probability or improbability of the information that they give. So at this stage, it's premature to give a finding on the credibility of Paul O'Sullivan. We are awaiting, obviously, as the course of the day progresses, where he will be questioned by members of the committee, and that's an opportunity for the committee to test the reliability of the evidence, to test his credibility ultimately, and then make that finding. So we employ, as officers of the court, we employ a whole picture approach when evaluating the credibility of the witness. So we need to allow that witness to give their full testimony. We need to obviously test it against prior versions of information that they've given before. And really, once that full picture comes to light, then it becomes possible to make a finding of credibility on that testimony.
So, Advocate Mthembu, one of the things that emerged yesterday was, of course, that Paul O'Sullivan has citizenship to 3 countries. So, you know, given that the line of questioning that the evidence leader took, is that something that is of concern? And, you know, which aspects of that could potentially be detrimental?
So at this stage, as we know that the Ad Hoc Committee isn't a court of law and there aren't any charges that are leveled against him as a witness, it's an inquisitorial procedure, it's a fact-finding mission, it's investigating into these allegations that were leveled by Lieutenant General Nhlanhla Mkhwanazi. So I think that his citizenship becomes a concern once that process proceeds into whether there are any charges that are leveled against him, to be able to secure his attendance, of course, to stand trial against those charges. And that then becomes an extradition matter, and then it's a matter of the minister to obviously initiate those proceedings to be able to secure his attendance. And as we know from recent constitutional court judgments, that that's not a process that has to be initiated by the prosecuting authority. It's a process that has to be initiated by the executive and the minister. So I think that that will become a concern later. It, of course, does provide context in terms of Paul O'Sullivan as a character, in terms of Paul O'Sullivan and his inner workings of the organizations that obviously fall under question in this ad hoc committee.
How serious a transgression would it be if it is found, and taking into consideration, of course, as you point out, that this is an inquisitorial process, but there were some questions around how Paul O'Sullivan actually obtained his South African citizenship. How serious is that particular matter if indeed it is found that he may have lied about certain aspects of that particular application and process?
Yes, so those are very, very serious allegations, and it obviously has implications in the sense that once the committee has obviously concluded its process and made its findings and submitted its report to the relevant authorities, then the prosecuting authority or any authority, if any, if it intends to pursue those allegations further, that can obviously attach some serious legal implications for Paul O'Sullivan and can obviously attach serious charges. So everything hinges on the findings that the committee makes, as well as the reports and recommendations that it makes, and whether any further process will actually take place once the committee finishes its tasks and the committee itself is dissolved.
And then is, of course, the question of his qualifications as well, and the fact that he did not submit a CV among the documents that he submitted to the Ad Hoc Committee. And then there were questions about which qualifications he indeed held and subsequent jobs that were applied for and what the conditions of employment may have been relating to those. Again, how serious would it be if it is found that O'Sullivan had perhaps misstated some facts in that regard?
Yes, so that all speaks to the credibility of Paul O'Sullivan as a witness. So all of this information, any false information that he may have stated before, any misstatements in his qualification and how he was able to infiltrate the South African Police Service, speaks to his credibility. How much can the committee rely on any information that he provides if it is found that he does have a tendency of misleading and misrepresenting the facts? So as I said before, that all speaks to the credibility of him as a witness and what that information and how it fits into the full picture that will then be used to evaluate his credibility, to test the veracity of his evidence and how much the committee can place reliance on any information that he provides to the committee.
So in other words, that particular determination is likely to have a material impact on the ultimate recommendations that this committee comes up with.
Absolutely, absolutely. It has a very material impact because if a witness is found not to be credible and if it's found that you cannot rely on the information that's provided by that witness, then that speaks to anything that is triggered by the information that this witness provides also falls under question and also falls to not be reliable. So it has an extremely material effect on what the recommendations the committee will make and any findings that they will make as well.
And then, of course, we also heard from Paul O'Sullivan alleging that people like the late Dudu Myeni, former President Jacob Zuma, former Police Commissioner Kamotso Pahlane, people like them and others tried to stop him from exposing corruption. Now, if we look at that, how crucial is that as testimony for the scope and, of course, the work of the Commission going forward?
Yes, so that information is obviously very crucial. Whenever persons of interest are identified in these proceedings, it triggers investigations into the truthfulness of the allegations that are made. So we know that ad hoc committee isn't a court of law, so they cannot obviously prosecute those people that have been identified as persons of interest. What they can do is trigger investigations into testing the veracity of those claims and trigger further investigations. And then if it is found that that information is credible and that there is other corroborating evidence that comes up in those investigations, as I've stated before, then obviously it's up to the prosecuting authority to determine how they proceed in pursuing those persons of interest that have been identified and what charges will be leveled against those people in the broader scope, of course, into these allegations that have been made by Lieutenant General Nhlanhla Mkhwanazi.
Well, and just a final question as we're running out of time, Advocate Mthembu, with regard to perjury. And this is not just for Paul O'Sullivan, but for everyone who's appeared before the Ad Hoc Committee, because we heard yesterday where some of the members were saying that the committee staff needs to go and find certain information to verify some of the information that has been posited before them. So if anyone has perjured themselves, what does that mean for them going forward?
Yes. So as I had stated before, that before any witness comes before the committee to provide their testimony, they are placed under oath or admonition. So they then are saying to the court, or rather to the committee, that the information that they are providing is truthful to the best of their knowledge. So if it is then found that there are people who falsified information, willfully misled the committee in any way, Section 17 of the act that I've described before attaches penalties to that. So when it's found that an individual or individuals have perjured themselves, it really levels charges, criminal charges of perjury against those individuals, and it carries sanctions of up to 2 years of imprisonment or a fine or both. So perjury has extremely serious implications, and especially because this testimony is provided under oath. If you perjure yourself, you open yourself up to criminal charges of perjury and penalties such as a fine and imprisonment of up to 2 years.
Well, Advocate Mthembu, thank you so much for helping us wade through the legalese here. That's Advocate Mbalenhle Mthembu, legal analyst and member of the Durban Bar, giving us her legal analysis of Paul O'Sullivan's first day of his appearance at the Ad Hoc Committee yesterday, and he, of course, continues today.